Vanessa Contreras here, and today I'm with Spar Bernstein's personal injury team, Moshe Baruch, David Levy, and David Moreno. And as we all know, construction is a tough job that can often be dangerous. I'm speaking with Moshe, David, and David today about a recent case in which they recovered $3 million. Wow. In a settlement for a gentleman injured on a job at a construction site. Moshe, can you share a little bit of the details on this case?
Absolutely. So in this particular construction accident, our client was on a high-rise building on the 43rd floor in a very, very huge project. And what happened was he was working on dismantling what we call a DOKA system, which consists of removing ribs and stringers from the actual base of the building, which makes up the frame of the actual building. And while he was doing that, he was removing the DOKA system, and the ribs and stringers that he was removing fell right on top of his body,
wow,
causing his harness and his body to slam to the floor.
How crazy. That's terrible. What were some of his injuries?
So the injuries in this particular accident, immediately after the impact had occurred, he lost consciousness. That's number one. And that's a big deal because when you lose consciousness, now you're talking about a possible traumatic brain injury. Luckily, however, there was no traumatic brain injury. After he regained consciousness, he immediately began complaining of pain to his lower back. He was rushed to the emergency room at Brooklyn Hospital Center where they conducted diagnostic testing, namely an MRI, an X-ray, and they found 4 transverse fractures to his spine.
Wow.
Those fractures required surgery, which he subsequently got a fusion to the L5-S1 level, and we knew that he had a herniated disc from the MRI that he received subsequent to the accident. So that was primarily his injuries.
Did the construction company try to avoid compensating your client?
100%, but fortunately, New York has very, very protective labor laws that helps protect construction workers, and they're very, very favorable to plaintiffs. So in this instance, they tried to deny the claim by saying that our client was the sole proximate cause of the accident. And what that means is that they did nothing wrong here, and that our client was completely responsible for causing the accident. But the labor laws of New York are very, very friendly, and especially under gravitational related injuries, such as this one. So whenever you're dealing with an injury, whenever you're working at a height. So in this case, our client was working on a construction site on the 43rd floor of a high-rise. He was hit and injured on a gravity-related risk type of work. And in this case, when, as Moshe just said, the ribs and the stringers that fell from a gravitational elevated standpoint onto his back. That means that our client falls under the protections of what's known as the Labor Law 240. And what 240 says, and all you have to do under a 240 case is show that the statute was violated, and that the violation of the statute, the violation of the law, was what proximately caused his injuries. So in this case, because we were able to show that there was a violation of law that led to his injuries, it was absolutely irrelevant as to what our client did, could have done, should have done to prevent it from happening, because of the friendly nature of the labor laws that we helped apply to our client.
Another major aspect in the case was, one of the main things they argued was that because he lost consciousness after the actual impact, he couldn't have possibly remembered how the accident occurred.
Wow.
So that's why I focus so much on witnesses. We got a witness to testify and say that he saw the ribs and stringers fall on top of our client.
Wow.
That was sufficient enough for us to get summary judgment on the issue of liability before trial, which means that when you got to trial, you have nothing to do with liability and who caused the accident. The only issue before the jury was damages, what his injuries are, and what the fair and reasonable compensation for those injuries are.
Yeah, and how were you able to prove your case?
Yeah, so actually I want to go back to your last question. Was the insurance company willing to pay, and at what point were they willing to pay? In personal injury law, as with criminal defense, as with any form of litigation, in order for you to gain leverage in a case, you have to be willing to litigate, right? So when the case was early on, we were building the case, we were gathering the medical records, we were really diligent with that. Obviously, Moshe just spoke about the witness that we got. We also, in that process, got photographs of our client laying on the ground with the ribs and stringers on top of his body, which also supports the allegation that everything fell on him, which is really great demonstrative evidence that you would use at trial. So prior to the case being at trial, the insurance company didn't value the case, right? Because there was no reason for them to. So their first offer to us was $400,000. And being the experienced trial lawyers we said, that's fine. Thank you for that offer. We're going to trial, right? So instead of sending one attorney, we sent our entire team, an experienced trial team, to show them that we mean business. So we started our trial, and the first part of the trial, the most important part in my opinion, is jury selection, right? That is our first opportunity to connect with the jury. And because this case was important to our client and important to us, all three of us at different phases of the jury selection made sure that we were there to connect with the jury, to make that initial impression that this is a serious case, we mean business, and we're here to represent our client. The next thing that we did in terms of proving our case, the case, as Moshe already alluded to, was all about the injuries and not at that point about liability, which makes the trial so much more streamlined for a jury and for even the judge to follow. So the star of our case was the client himself. And all of this is below the surface. It took a lot of prep work to get him to articulate what happened to him, right? Because he did lose consciousness. So having him review his medical records, learn the complicated terms so that he can come across as believable and also endearing and someone that the jury wanted to award money to. So we built the leverage to the point where there was no reason to prolong the case anymore. We got the defense attorney to go to his adjuster and offer us $3 million. And at that point, there was no risk for us because we put on such a strong case, our client was such a strong witness, and we were so prepared as a team that we got the highest possible outcome for him without the risk of the jury ever even rendering a verdict.
Now, it's so important to do the liability aspect before the trial because when you get to trial, the first thing you tell the jurors, even at jury selection, is we've already established that these people are at fault for the accident. Now, automatically, in a layperson's mind, when you say somebody caused an accident and they're 100% responsible, the first thing in your mind is, wow, these people screwed up.
Right.
So when you have that automatically from the beginning, the inception of the trial, in the back of their minds, they know somebody screwed up here and somebody needs to pay for that screw up.
Yeah.
As attorneys, our job is to put as little risk as possible in a case. And if we know that we're going to have to take this all the way to trial in order to get maximum compensation for a case, we have to do the prep work behind the scenes. Trial is 2 to 3 years away from a case whenever it comes in through the door until you actually see a judge and a jury. During those 2-3 years, we crossed all our T's, we dotted all our I's, and we ensured that we were able to get liability predetermined so that that question would never ever see a jury. And all we would have to do at trial is focus on the issue of how much money is he getting.
And team, now you could have been those guys in that team that settled for $400,000, right? $400,000 is still a reputable amount of money. Now, why did you not settle?
So this is one of the things I always say to my prospective clients when they come see me. They say, well, why should I choose you as a lawyer? And I tell them, I say, we have an entire team. We have David Moreno, David Levy, and myself, Moshe Baruch. We're very aggressive, we're ruthless, and we fear absolutely nothing. And when I mean that, I say, if the insurance company doesn't want to offer more than we believe is reasonable, fair and reasonable compensation, again, we're going to trial, and we're not going to hesitate at all. We have an entire team of litigators here. We all came to this trial prepared. We covered absolutely every single corner. No rock was left unturned. And so that's why I say, you need to get lawyers who are aggressive, who understand how far the insurance companies are willing to go, and you need to hit them very, very hard to get the number that you want.
Yeah, and that you guys did, and you got the number. I'm sure your client wasn't even expecting that much.
He wasn't. I mean, frankly, we told him it was a $3 million offer, and he was shocked because first the number was $400,000.
Right.
And that was 2 days before we started the trial. And so when we started the trial, the numbers started to go up very, very slowly. And eventually we got a $3 million offer, which we had to accept.
Gentlemen, excellent job on this case. Congratulations, team. The best of the best sitting next to me. Thank you guys so much for your time. Brad Squad, you already know, if you need anyone for a personal injury case, you can always call us 1-800-529-5465.
Prior successful results do not guarantee a similar outcome in the future. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.